We all do it. You drag a sharp photo into your company newsletter, save a slide from a colleague's presentation, or swipe a funny filter over an image on your phone. It takes 2 seconds. Usually, we assume that as long as we credit the creator, or we're doing it for a good cause, we're in the clear. But the law operates on a much stricter baseline. Copyright is an absolute monopoly. By default, the person who created the work controls exactly how it gets used, and no one else has a right to touch it. Your good intentions do not cancel out that monopoly. Without explicit permission, that casual borrowing is legally considered theft. If that monopoly were absolute in every situation, society would freeze. Teachers couldn't share articles, journalists couldn't quote politicians, and cultural critique would grind to a halt. High courts, like the Court of Justice of the European Union, recognize that this monopoly needs a counterweight. That counterweight comes in the form of legal exceptions. These are highly restricted scenarios where society is allowed to bypass the creator's monopoly to keep information flowing. To prevent these carve-outs from being abused, international law relies on an ultimate gatekeeper known as the three-step test. The law guards these pathways with a rigorous legal filter, forcing every unauthorized use to survive a specific gauntlet. Picture this test as a multi-layered filter. Step 1, your use must fall into a specific, legally defined case. The scenario has to be explicitly written in the law. If it passes that first grade, it hits Step 2, the market test. Your use cannot harm the normal exploitation of the original work. In short, your copy cannot compete with the creator's ability to sell their own piece. Finally, it reaches the tightest layer. Step 3 dictates that the use must not cause unjustified prejudice to the author's legitimate moral or economic interests. You cannot tarnish their reputation or exploit their labor unfairly. This test is completely cumulative. Failing even one of those 3 layers causes the exception to collapse, leaving you with an illegal infringement. Let's run a common scenario through the gauntlet. A teacher shows a 2-minute film clip in class, or quotes a paragraph in a syllabus while citing the author. This slips right through the filter. The usage is short, it generates 0 profit, and it serves a highly specific educational purpose. Now, picture a business republishing an entire newspaper article on their blog to drive web traffic, or an instructor taking another professor's course materials and selling them online. These actions crash hard into Step 2. They act as substitutes for the original work in the market, or they seek commercial gain off someone else's effort. The physical length of the excerpt and the financial intent of the user are the critical tripwires. Cross them, and your education or quotation exception instantly vanishes. The law also protects humor. Through the parody exception, you are allowed to mock, satirize, and creatively divert protected works. A valid parody must evoke the original work, so the audience gets the reference, while remaining perceptively different. Most importantly, it actually has to be a joke or a critique. But try using a famous pop song or a highly recognizable cartoon character strictly to sell a commercial product, then labeling the ad a parody to avoid paying licensing fees. Commercial exploitation disguised as humor causes unjustified prejudice to the author. It fails Step 3 of the gauntlet immediately. Parody is the only legal exception allowed to be funny. However, it remains strictly an avenue for critique rather than an alibi for brand marketing. These boundaries apply to the physical world too. You can make a private copy of a work for your own personal use at home. But the second you distribute that copy online, you break the law. There are also protections for navigating public spaces. The freedom of panorama and incidental inclusion exceptions allow you to photograph areas that happen to contain copyrighted architecture or public art. Look at this photo. The statues in the background are copyrighted characters permanently placed in a public garden. Because the statues are part of a broader public scene, capturing them is perfectly legal. Location and context dictate the legality. The law protects your right to capture reality as you find it, but it prohibits isolating and commercially exploiting the protected art within that reality. Think back to those everyday digital habits. It should be clear now why that casual copying is legally hazardous. The law interprets copyright exceptions narrowly, limiting them to essential societal functions rather than personal convenience. If your use replaces the original work or is driven by commercial gain, assume the exception collapses. When in doubt, ask the creator for a license. Staying within the law requires honestly running your intentions through a legal filter to respect the creator's monopoly. Copyright law is complex and varies by jurisdiction. This video provides educational information, not legal advice. Always consult a professional for your specific situation.